Excuse me, everyone. We're going to start in a few minutes. Or actually, right now. Excuse me, everyone. Thank you. Hello. My name is Jennifer Giordano-Coulthard, and I'm the president of the Intellectual Property and Cyber Law Society at Duke Law. I welcome you to the law school and to the 6th annual Hot Topics in Intellectual Property Law Symposium. This year we have a record number of registrants. We have over 150 people participating, both here at the law school and watching the webcast live. The symposium is Duke Law's only completely student-run conference, and it is a testament to the passion that the students here at Duke Law have for IP. This year also marks a strengthening bond between the IPCS and the Duke Law and Technology Review, one of the most innovative law school journals in the country. Our goal is to have this symposium grow every year, becoming a preeminent IP law event regionally and nationally. I'd like to make a few quick acknowledgments. First, I'd like to thank the IPCS board. Their names are listed in the program and on our website. They've worked hard over the past several months, and this event is a testament to their skill and commitment. They're all wearing distinctive name tags like my own, so feel free to stop and speak with them at any point today to talk about the event or about IP law at Duke in general. I also sincerely thank our sponsoring organizations, both old and new. This event and the growth of the IPCS program would not be possible without their generous support. Their names are displayed here on the screen, as well as on our website. Our patrons are Dal Lones, Kilpatrick Stockton, and McDermott, Will, and Emery. Our sponsor is Myers-Beagle, Sibley, and Sachovich. Our contributors are Alston Bird, the Duke Law Center for the Study of the Public Domain, the Triangle Intellectual Property Law Association, Weil Gotshal, Wilmer Hale, and Womble Carlisle, Sandridge, and Rice. I thank Dean Bartlett, Duke Law's IP faculty, and the members of the Career Service Department and the Office of Student Affairs, whose advice and support this year have helped make this fantastic event happen. I also sincerely thank the Honorable Judge Timothy Dyke, our keynote address, who made extraordinary efforts to be here today, all of our panelists, and our breakout session speakers. They are here to talk about what truly are the hot topics in intellectual property law. Last but not least, I thank you all for attending, both all of our practitioners in attendance whose experience will add depth to our discussions, and all of the students, both here at Duke Law and at local universities, for your enthusiasm. Thank you all, and welcome. Before I ask Dean Bartlett to step to the microphone, I just want to let everyone know that we'll be sharing this room over the luncheon with attendees of the Duke Law Family Weekend. So we ask that as soon as the morning session ends, everyone move out into the loggia where you registered and then proceed on to breakout sessions and lunch. Thank you very much. I'd like to present Dean Catherine Bartlett.
Thank you, Jennifer. In introducing Nobel laureate Joseph Stiglitz last week at the Frye Lecture in Intellectual Property, I mentioned that the Frye Lecture is one of a number of important events that support Duke's exploding interdisciplinary and entrepreneurial strengths in intellectual property, along with other areas related to science, technology, innovation, and entrepreneurship. This Hot Topics Conference is another. Entirely student-initiated, as Jennifer said, year after year it has brought together academics, practitioners, and students to enrich understanding of the hottest and most interesting and relevant subjects in intellectual property. When this Hot Topics Conference began 6 years ago, students had to struggle to define the undertaking, recruit sponsors, persuade people to come, get the word out among the practicing bar. And as it's become more well known by experts in the field, better supported by law firms with special standing and reputation in the IP area, and more expected by intellectual property practitioners, some of the original struggles of the effort have dissipated, replaced by the struggles of a more mature operation, which is most especially keeping up with the high expectations that seem to be increasing every year. Once again, it looks like this student group has raised the bar at both with respect to content and with the organization of the conference. I want to thank Jennifer, whom you've just met, and also I understand Grant Reeves has played a really important role along with many others. I don't know if Grant is in the room. I don't happen to see him, but maybe he's out in the loggia and we'll understand our appreciation for his leadership. I also, like Jennifer, want to thank the sponsors for their support and generosity, the speakers for the gift of their time and their expertise, all of the participants for coming, those of you who may be new to Duke, or some of you I recognize as graduates from some either recent graduates or not so recent graduates. If you haven't had a chance to see what's happened to this building since the last time you were here, I hope you will have time to poke around. I hope you'll all enjoy the conference. Again, thank you for coming. If there's anything that you need, please be sure to let us know. Now I introduce one of the centerpieces of Duke's explosion in intellectual property, Professor Arti Rai.
So we have a lot of serial introductions. Our first panel is on hot topics in patent law 2006 and 2007, of which, as many of you know, there are many, given that the Supreme Court has become so actively interested in patent law over the last few years. We have a stellar panel today, and I will introduce them in alphabetical order, although that is not the order in which they're speaking, but it's easier to do it that way since that's the order in which I have their biographies listed. Dennis Crouch is a visiting assistant professor, of law at Boston University Law School and has recently accepted a permanent position at the University of Missouri Columbia Law School. He is famous to many in the patent law community already at his tender age because he is the creator of the Patently Obvious or Patently O blog, which has received many awards and is a blog to which many of us turn regularly to see what the latest patent gossip is, and more than just gossip, actually, the latest interesting commentary on various Supreme Court opinions, Federal Circuit opinions, and the like. He's also of counsel to McDonnell, and I'm going to butcher these names, Bonin, Hulbert, and Bergnoff. So welcome to Professor Crouch. Next we have Professor Duffy, who is just a stellar academic. He's a professor of law at George Washington University Law School and also of counsel to Fried, Frank, Harris, Shriver, and Jacobson. Professor Duffy has been known to many of us for many years and is a good friend of mine. But in addition, he is the driving force behind the famous or infamous, depending upon your point of view, KSR case, which should be decided anytime. We were hoping that it might be decided even before this conference, but in any event, he will give us the inside scoop on all things KSR related, and frankly, all things Supreme Court related as well. He's formerly a clerk for Justice Scalia, so he knows both the Federal Circuit and the Supreme Court very well. Then next we have Stephen Gardner, who is a partner at Kilpatrick Stockton and co-chair of the firm's patent litigation group. He was recently elected to the North Carolina Magazine's 2007 Legal Elite because he is one of the top patent attorneys in North Carolina, and he's listed in the 2007 edition of the Best Lawyers in America for Intellectual Property Law. And we're just delighted to have him. He has all of his degrees are from various North Carolina schools, so he has been around North Carolina for a long time and is really a leader in North Carolina law. Next, we have Clarisa Long, who is a professor of law at Columbia Law School. She recently joined the faculty there as the Max Mendel Shea Professor of Intellectual Property Law, a very honored position at the Columbia Law School. She is a former clerk for the Federal Circuit and has written prolifically and also some very interesting articles on a variety of subjects on the theory of patent law, empirical work in trademark law, and I always am eager to read everything Professor Long writes because it's invariably very enlightening. And then finally, last but certainly not least, we have Ron Pabis, who is a partner at McDermott, Will, and Emery in Washington, D.C. He is a member of the Intellectual Property Group and the Media and Technology Department. And he has assisted and acted as trial counsel in courts throughout the country. His litigation practice includes or involves a wide range of technologies, including medical devices, semiconductors, and computer-related technologies. We are very delighted to have all 5 of these very eminent individuals on our panel today. So, shall we have them come up? I know you're reluctant. They're all hanging back for some reason. We're going to start with Professor Duffy, whose talk is provocatively entitled "The Loss of Invention." As I understand it, all the speakers are going to speak, and then we'll have some discussion and then more robust discussion in our moderated panel.
Thank you, Arti. I wanted to begin first by thanking Duke Law School for inviting me here, and a particular thanks to the students who also were actually responsible for inviting me here. And so far, it's been a very enjoyable trip, and I wanted to thank them for making sure everything runs smoothly. Now I'm going to try and make things run a little less smoothly, because hopefully I'll say some things that are not standard. My talk is about the loss of invention, and my basic thesis is that if there's a challenge to our patent system today, a fundamental challenge, it's that the patent office, the practitioners, and the courts particularly, and I'll focus mostly on the courts, have lost sight of invention as sort of the fundamental core value in the patent system. And I'm going to discuss 3 of the biggest topics that are in patent law: non-obviousness, infringement analysis, and I'll just touch on briefly patentable subject matter. And I think in each of these areas, the key problem is that the courts do not anymore look for what is the sort of difficult thing, what is the hard thing that this person has claimed to have done. And instead, we've gotten caught up in legal jargon. And that distances us from the technical merits of the invention. And I'm going to compare, actually, in each case, I'm going to compare cases that have either been recently decided or that are pending, the KSR case is one of them, with some older decisions about how I think legal analysis in this field should be done. And in particular, I'm going to focus on the decisions of Judge Learned Hand, who I think is perhaps the best patent judge there ever was. He didn't have a technical background, but he was an extraordinarily great judge, not just in other fields, but in particular in the patent field. Let me begin with non-obviousness. I'm going to talk about, which this probably doesn't surprise anybody, the KSR case, which, as already mentioned, I've had a little bit of a role in. KSR involved a technology. Actually, I have a slide here showing a basic technology. It's very simple to understand. This is an adjustable gas pedal. And what this diagram shows, this is an animation that's part of the record, is a prior art adjustable pedal that was about 10 years old at the time that the alleged invention occurred. And prior to the mid-1990s, when this invention allegedly occurred, there was most pedals worked on a mechanical basis. In other words, when you stepped on your pedal in your car, ultimately you were you were putting some mechanical force into some form of cable. You can see the cable right up here, the cable attachment. That cable would communicate the mechanical energy into something called a carburetor, which would essentially control the speed of your engine. That's what you did when you stepped on the gas pedal. Adjustable pedals to adjust for people of different heights, that was also very old in the art, being probably 2 decades old in the art. Now, what the alleged invention was in KSR is that all of the claim elements, all of the elements in the invention were satisfied by this piece of prior art with one exception, and that's this little blue device which is put on the pivot which rotates when you step on the pedal. That blue device is an electronic sensor. Now, the district court said, let's figure out what's really going on here. What's really going on here is that in the mid-1990s, the computer revolution basically entered the automobile industry. And instead of having carburetors with mechanical linkages trying to figure out how much gas should go in your car, all of that was replaced by a computer. That was not done by this alleged inventor. It instead was just a development in the automobile industry, perhaps done by many different researchers. The automobile industry said to its pedal manufacturers, who supply pedals to cars, you can't give us ones that have mechanical linkages anymore. You have to give us a pedal, whether it be an adjustable pedal or some other form of pedal, you have to have an electronic sensor. You have to communicate with what's going on in the engine now, and that's run by electronics. So instead of a mechanical signal, we need an electronic signal. What happened in this case is that, in order to make the alleged invention here, all you have to do is take the prior art device and put on an electronic sensor onto the pivot. And indeed, the process of updating existing pedals had already been going on. This particular style of pedal had not yet been updated. But many other forms of pedals had been updated with these electronic sensors. So much so that the electronic sensor was something that you could buy off the shelf, and it had instructions that said, put this on the pivot. The district court said, well, this is obvious as the day is long, because even under the Federal Circuit's teachings, what we have here is a development that is just brought about by the march of technology that has nothing to do with this inventor. Indeed, the inventor himself was told by the automobile manufacturer, we need a pedal, an adjustable pedal that has an electronic sensor attached to it. So the district court held this patent invalid on summary judgment. Now actually we need to go back here. Okay? When it gets up to the Federal Circuit said, no, 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 you cannot do that. You cannot do that because under our teaching suggestion motivation test, you don't just need some sort of general story about the technology. You need to tell us specifically why the person would have put the electronic sensor in the particular place, in the exact spot that was claimed in this way. So in other words, if you look at the next thing, there are many different pieces that are moving here. All of them actually you could put a sensor on all of them. So why this particular spot? Why not some other spot? Now, the answer to that is, well, you probably could put this sensor in many different spots. This is one of them. You can't find a particular reason why it's done this way. You might be able to find a particular reason why it's done this way, but you might just say, well, this is one good place. There are many good places. This is just a way of doing it. It's an obvious way, but you can't say within that set of the universe of obvious ways why this way was chosen more as opposed to some other way. It's just a permutation. It's a random permutation of existing technology. Nonetheless, this was held, the Federal Circuit reversed the district court, and that is the case that is being appealed to the Supreme Court right now. And I think the fundamental difference between what happened at the district court is that the district court, I think, at least was trying to understand what this person's contribution was, what was happening in the art, and what this person's contribution was, and looked at that art and found nothing. Whereas the Federal Circuit was looking for very formalistic, particularized findings about how to match the claim language to a particular, to some specific teaching motivation or suggestion. And that, I think, is just the wrong way to go about the obviousness inquiry. I think a better way, actually, I don't want to just criticize the Federal Circuit. So I actually think that there's also problems with some Supreme Court decisions. Graham versus John Deere, which you probably all have read at some point or another, or if you're first-year students, you will read this if you ever take patent law. It's a very famous decision. And we all know that in this case, the Supreme Court evaluated this supposedly new combination, and the only difference between it and the prior art that was argued at the Supreme Court was that it provided a greater degree of flex in a certain kind of plow shank. And one of the things that struck me about this decision is that in the middle of the opinion, the court says, Graham did not urge before the Patent Office, didn't disclose or urge anything about this flexing, this greater degree of flexing, that supposedly what the Supreme Court is now saying is the core of my invention. This is my contribution to the art. It's nowhere in his specification. It's nowhere mentioned in the file history in the prosecution. If this was his invention, then I think the criticism of the the Graham case is not that the Supreme Court invalidated the patent, but that the Supreme Court gave this patent so much attention and care that it actually should have stopped with this sentence and said, look, your allegation is that you invented a greater flexing method. That's not mentioned at all in your specification. You said nothing about that. If it is true that your plow provides greater flexing, you didn't know that at the time. You had no clue about that. Instead, it was just another random permutation of various mechanical parts. In fact, Graham, when he applied for this, thought it solved a couple technical problems. The reason he had to change from those technical problems, which he thought he solved and he stated in his specification, to this flexing problem, is because he didn't see all the prior art. There was a piece of prior art that solved both those problems. And the Supreme Court should have just ended the opinion there and said, this is a patent that is just obvious. And that, I think, is some of the problems that we have with obviousness do trace back to the Graham decision, I think. Now I'm going to show you a Judge Hand opinion, and this is a very simple invention. Judge Hand eventually describes this as obvious, but the key difference here is that it's in a way very similar to the KSR case. What happened in this case is that the patentee had figured out a way of actually putting the vitamin-rich fish liver oil, which was a type of way to get vitamins in old technology, and a way to marry that with cocoa butter and some masking ingredients that would mask the smell. And the cocoa butter actually prevented oxidization of the vitamins. He said, so here is the basic invention. But in fact, actually, this exact technique and exact combination was in the prior art with one difference, which is that it used to be you'd use vegetable oils as the sort of the source of vitamins. And now this person is using fish oil. In fact, the reason why people used to use vegetable oils was because that was the sort of standard source of vitamins at the time. There was a discovery, not by this inventor, but by other inventors, that fish oils were rich in vitamins. So this person took a standard prior art tactic of a way to preserve the vitamins and sort of mask their odors, and changed it, updated it, because of the discovery of fish oils being also rich in vitamins. So that was the alleged novelty. And Judge Hand says, this is his approach. He says, look, in judging whether something is an invention, we regard history of the art as of much greater importance than our own untutored judgment about what advances demand imaginative originality in specialized field. Nothing could be less reliable than our naive impressions based on gross appearances. The books never tire of warning of them. And the ultimate message here is that Judge Hand is going to look in detail at the art, at the invention, and he's going to base his legal judgment on that art. And that's what he ultimately does. He says this case here clearly indicates the problem of preserving and masking vitamins derived from fish livers was no different from that of doing the same as those derived from vegetables, or also lamb livers was also used in the prior art. And instead of saying, where's the suggestion in the prior art, telling the challenger to the patent, where's this teaching, suggestion, and motivation, he just says, nothing in the record here suggests there was any difference between these two things. Nothing. Looking at the inventor to say, what was difficult about this? And finding no answer, that there was no difficulty in updating this old prior art in light of the new source of vegetables. And that, I think, is sort of the best analysis. It cuts through the jargon and the verbal formulations and looks directly to the history of invention, or alleged invention in this case. Now, I see I'm running short on time. I want to say that I will just talk just about infringement. A recent case, which you, if you're a patent practitioner, you're familiar with, an en banc Federal Circuit decision called Phillips versus AWH Corporation. And this opinion goes on for 20 or 30 pages. And it's about the infringement analysis, about whether a patent claim is going to be infringed and how that patent claim should be construed. And if you look at that opinion and distill it down and say, what is this person's invention? You find one sentence which tells you nothing. It tells you nothing about the art. It tells you nothing about this person's contribution. And there's no, I think there is absolutely no way you can fairly go about construing what an invention is, what kind of rights somebody should have in a patent, unless you know what the person's invention is, what their contribution is. And in fact, I think in this case, the Federal Circuit came up with an answer in this case. Here's the claim. It's of course very long. It's another of these permutation claims. You can read this claim. And this claim, though claims are by statute supposed to distinctly point out what you deem your invention, you could read this claim and you have no clue what's the contribution of this person to the art, other than that this is another random contribution of a way to make what is a wall with baffles in it. This is the kind of wall that was a picture from the outside. The yellow surface is the wall. Inside there are these baffles, which become crucial in the litigation, because the accused infringing device does not have baffles that are at angles. The holding in this case was the specification actually said that one of the important things about this invention was that it stopped things from going, the baffles stopped things from going through the walls. That was an important thing. So you could have projectiles like bullets and things like that that are trying to go through the walls, and the baffles will stop them. The Federal Circuit said, well, that's one use of baffles, but maybe there could be another use. Maybe that, baffles also could baffle a flow of insulating material inside the wall. There's nothing in the patent about that. Absolutely nothing. And there's no evidence whatsoever that was a problem in the prior art, that sort of preventing insulation from moving from one part of the wall to the other was something this inventor tried to solve. So again, I think this is a case where we have a long opinion that talks a lot, that cites a lot of cases, and yet tells us nothing about the art. And that is the way that we are supposed to engage in figuring out what rights an inventor should have. I see I'm out of time, so I want to close on that. In the question and answer session, I have a good example of, again, a hand opinion actually construing the Wright brothers patent, where there was a very important problem with the Wright brothers patent. And Judge Hand looked at the technology, and he used a doctrine that you just simply don't see anymore in the Federal Circuit. He tried to decide whether this was a pioneering patent or not, and he ultimately decided it was. But you don't see any attempt these days, either at the Federal Circuit or the Supreme Court, to actually understand how great a contribution this person made and use that as the guiding doctrine in figuring out the scope of invention. And hopefully in the question and answer period, we can also discuss the patentable subject matter, which I think is an area where also we are, particularly the Supreme Court, or at least Justice Breyer, seems to be lost in metaphysical distinctions without really trying to understand the contributions to technology. Thank you.
Not every.
Maybe it would be easier to have the panelists be here so that you could actually see the presentations without craning your neck.
There's a thing here though too.
What's that?
It's shown on here.
Oh, can you turn that then this way?
Perhaps if it-
Oh, for us. Oh.
Oh.
Oh, no, but but this is for the speaker.
This is for the speaker,
That's for
yeah.
the speaker.
And in addition, I take it that your heads are blocking a little bit.
Okay.
That was the less delicate part of what I was.
Thank you. I'm going to address two parts of claim construction case law that I'd like to alert you to and discuss with you. As Professor Duffy explained, patent claims are the words and phrases that an inventor uses at the end of their patent document to define what it is that the inventor views as his or her invention and what the inventor is claiming as his or her property right, what they might have a right to exclude others from making, using, or selling. And the interpretation or the determination of the meaning of those words and phrases is what we refer to as patent claim construction or patent claim interpretation. It's critical to nearly every patent case. Claim construction or claim interpretation is critical to nearly every patent case because you have to determine what is it that the inventor is claiming to have the right to exclude others before you can decide what is it that they can exclude and before you can decide whether their claimed property right might be valid or not. The two things I'd like to talk to you about, one is since the Phillips case, and particularly in 2006, there's been a marked trend by the Federal Circuit to interpret claims more narrowly than it had before. And it begins to address some of the things that you've pointed out. It doesn't get all the way there, but it begins to do so, and we'll talk a bit about that. And also provide a little commentary and a little discussion in the time we have on the Federal Circuit's apparently is going to reconsider a case called Cybor. And in that case, in Cybor, the Federal Circuit said that it was not going to provide any deference to the district court judge's claim interpretation and would review it de novo. But it appears that there are several judges on the court who would like to reconsider that ruling. I'd like to provide some history first. And in 1995, the Federal Circuit issued its in-bank Markman decision. In that decision, that's viewed as a groundbreaking claim construction decision, and that it told us a couple of things. One, that the claim construction should be a question of law that's addressed by the district court judge and by the Federal Circuit, and that the focus of claim construction is an objective test of what one of ordinary skill in the art, one of ordinary skill in the particular field that the claims go to, would have understood the claim term to mean. So Markman told us to focus on that and to use sources, to look at the claims, the specification, and the prosecution history of the patent, and also that you could use extrinsic evidence, things like dictionaries, expert testimony, things that are outside the four corners of the patent document and outside of the documents that go back and forth between the inventor's counsel and the patent office that's referred to as prosecution history. Things outside of that are called extrinsic evidence, and those things can be used to aid the court's understanding, but aren't supposed to be used to change or alter or contradict the meaning of the claim term. So that was 1995. Now, in 2002, the Texas Digital case came out of the Federal Circuit. It was a panel decision, and the Texas Digital case gave us a way of construing claims. It overly focused on the objective part of the test. It viewed, to look at how a person of ordinary skill in the art might interpret those claims, the Texas Digital case said, well, first, if you're looking at a claim term, look at the dictionary meanings of those. And you have, let's say, A, B, and C, the three definitions of that claim term. And this is good. Looking at dictionaries and treatises and things of that nature, that's good because those are fixed in time. They're not influenced by litigation like an expert's testimony might be and like a counsel's argument might be. So look to that first, and then look at the intrinsic record. Look to see, okay, which of those three claim definitions, A, B, or C, that are from the dictionary or from the treatise or what have you, which of those are consistent with the words used by the inventor in the patent specification. And the one that's consistent, that's probably your claim construction. And if all three are consistent, all three, the scope of that claim term probably reaches the breadth of all three of those definitions. And, well, if the specification, if those three definitions are inconsistent with the specification, the definition must be something else, so then pay more close attention to the specification. So the interesting part, or the attractive part of Texas Digital was that it gave district courts and gave us practitioners some rules, a methodology on construing claims. And it caught on. It was used quite a bit because it was an algorithm, so to speak, on how to go about our job. Well, the court in 2005, the Federal Circuit took the Phillips case in bank and said that Texas Digital, that methodology was wrong. That's not how to construe patent claims because it gave too much reliance on extrinsic sources, too much reliance on dictionaries. Instead, what needs to happen is you need to concentrate on the intrinsic record. You need to look at the specification, look at including the claims, look at the prosecution history. That evidence is what's going to provide you with the proper claim construction, and you should give those terms their ordinary and customary meaning in view of the specification. What happened? So that was in 2005. So you have the court correcting, so to speak, a panel decision and saying, no, that's not the way to do it. Instead, focus in on the specification, focus in on the intrinsic evidence. The important part, I think, about what I'd like to share with you in the first part of the discussion is what the Federal Circuit, how it's applied the Phillips decision. And the way it's applied the Phillips decision in 2006, there's a marked difference in the scope that claim terms are being given by the Federal Circuit. It's much narrower, I believe. It's giving a much narrower claim construction, much more apt to interpret the scope of a claim term to the embodiment or the example of that element that's given in the specification. And I'm going to share just a few examples with you just to let you see what I mean. The first one is the Honeywell decision. In Honeywell, the claim term at issue, was the phrase fuel injection system component. Fuel injection system component. And while we can't know for sure, right, probably under a Texas Digital type analysis or a pre-Phillips type analysis, the claim phrase fuel injection system component probably would have been construed something like a component of a fuel injection system, something along the lines of a structure that it can be found within a fuel injection system. Let's look at the specification. Oh, there's a fuel filter. That's an example. So we're going to interpret it as a structure that can be found in a fuel injection system. Fairly straightforward. In Honeywell, though, the Federal Circuit said, well, because Phillips is telling us to pay much closer attention to the specification, and when we look to the specification, we see there that in the specification, a fuel filter is referred to as being very important, that this invention relates to a fuel filter, the fuel filter is this invention, because a particular part of a fuel injection system component was referred to as being very important to the invention, we're going to construe the phrase fuel injection system component to be limited to a fuel filter. So we look at the specification, what's indicated as being the invention as part of the fuel injection system component. We're going to keep that narrow. It's not any component of a fuel injection system component. It's that component that was described in the specification of the patent. Another example, I think a clear example, is the on-demand machine case. There, the claim term at issue was customer. Really plain, thank you, really a plain word, not a scientific term, customer. And as you might expect, the district court said, well, customer means one who buys goods or services. Fairly plain. Well, the Federal Circuit said, well, that's not correct. When you look at the specification, when you look at the written description of the patent, it repeatedly reinforces the use of the customer as a retail customer. The example of a customer given was a retail customer. And the focus of that patent was on an initiation by the customer of printing and binding, and it was conducted at the customer site, direct retail customer. And so because the specification emphasized that, we're going to limit the interpretation of the word customer to a direct retail customer only. That would not have been the case under a Texas Digital, or I think under a pre-Phillips analysis. MPRO 2 does some of what you referred to, Professor Duffy, on. There, the claim term at issue was host interface, and the background portion of the claim of the patent that describes what was going on beforehand said, well, a big drawback of what came before was using serial connections. And in the claim, in the written description, it described as an example of a, quote, host interface, which was the term at issue, it described it as an example, a parallel interface. And normally, under normal terms, you don't think of a host interface as being strictly either parallel or serial connection. You just think of an interface that hosts. But here the court said because the specification emphasized the importance of a parallel connection, the claim term host interface is going to be limited to a direct parallel bus interface. There's other examples. I'm going to skip those in light of time. Curtis Wright, in a system claim, limited the interpretation of adjustable to a particular time. Dentsply limited the interpretation of tip of the iceberg, tip of my finger. It limited the interpretation of that tip to a separate tip, something that was separated from the main body of an object. So in all of these cases, there are other cases besides the ones given here. Planet Bingo, Cook Biotech, Abraxas, Bicon, SRAM, all of those cases from 2006 from the Federal Circuit, I think interpreted claims more narrowly than they would have done under Texas Digital or that they would have done prior to the Phillips case. What does this tell us? A couple of things. One is that I think the Federal Circuit is taking steps towards defining the claim term as what the invention is. It's not quite as far, but I think that's part of what we're seeing. Practically, there's a greater risk if you represent clients and you're trying to protect their invention. You have to recognize that we have to do more. We have to use claim differentiation more. We have to put in more examples to make sure that we can capture the full scope of our clients' inventions as opposed to only being limited to the one example that might have been given in the patent document itself. We can also expect these cases to start making their way into the district court opinions over the next couple of years and seeing the district court starting to narrow claim construction as a result. Second topic that I'd like to quickly address with you alert you to really is, you may recall in 1998, the Federal Circuit in the Cyborg case took that case in bank to say, we're going to review claim construction de novo. We recognize the Supreme Court in Markman said it's a mongrel practice. We recognize that there may be some credibility determinations, but the Supreme Court is saying this is a question of law, and we're going to review it de novo. In the Amgen case in 2006, three judges, in dissenting from a denial of the rehearing in bank, said we would reconsider Cyborg. Really reconsider it altogether. Another three judges, and I think in a bit more reasonable dissent, said that we would reconsider part of CYBOR, but so there's 6 judges and there's 12 judges of the 12 judges on the Federal Circuit who are saying that they would reconsider CYBOR at least in part. So one can expect that to occur at some point in the near future. There's all sorts of permutations of what could happen. Discussion of, okay, well, maybe there are some credibility determinations in the rare case, and so in those situations, we're going to review those decisions, those things, findings under the clear error standard, which would make some sense. That would be rational. Thank you. But I think there's another group who I think would like to reconsider claim construction altogether and say, in general, that much more deference should be given to the district court on the ultimate finding. We shall see. The reasons Judge Michel gave for reconsidering here, I lay them out in 4 of them. I won't go over all 4 in the interest of time. But what I'll mention about it is really, this is not what we need, I think, a reconsideration of CYBOR. I don't think, if there's deference given to the district court's interpretation, that means if my patent right, interpreted by a district court judge in Raleigh, if that interpretation is given deference, a court in Durham, that's in the Middle District of North Carolina, Raleigh's in the Eastern District, Durham's in the Middle District, a district court in Durham gives the claim a different interpretation that also should receive deference, and both of them receive deference, enough deference that they have 2 different claim terms, so within 20 minutes of each other, you have a different property right here, and you have a different property right there. I don't think that's a good result. That's not what we need. What we really need out of the Federal Circuit is an in-bank Vitronics type opinion. And what I mean by that is an in-bank opinion that gives us some rules and guidance similar to what Texas Digital did, but in-bank, and similar to what this case Vitronics did about 11 years ago or so, that gives us some rules, gives us some clear guidance not by this panel or this panel or this panel, but by the court as a whole. And I'm out of time, so I'm going to close there. I might mention the other things during the discussion part of the discussion. Okay, thank you.
Good morning. I'm Ron Pabis, and I'd like to thank you for inviting me to come and speak this morning. I'm going to talk about remedies a little bit, and in particular about permanent injunctive relief and the Supreme Court's decision in eBay from last May. And I think it's important to talk about this decision for a couple reasons, other than the fact that arguably it is the reason that you can still purchase Britney Spears' hair online. But this decision arguably affects the value of patents. It does away with a long-standing presumption that a permanent injunction will issue if you prove infringement, and also because there's been some development since this decision came down in May at the district court level that I think gives a window into what you can expect if you're putting on a case and you're trying to get injunctive relief. So, just to back up, prior to the eBay decision in May, absent exceptional circumstances, the general rule was a permanent injunction will issue once infringement and validity had been adjudged. So if you were to win at the district court and you were to prove infringement of a valid patent, you were pretty much certain you were going to get a permanent injunction. And that is a powerful tool when you go to the negotiating table and you try to settle that case. No matter how good you think your appellate arguments might be, if you're facing an injunction, your client, a good portion of your clients, products are the accused products in the case that have been found to infringe, you're likely going to have to settle that case before taking that to an appeal. What happened in this case, just real briefly, is Merck Exchange had a business method patent directed to an online marketplace. They sued eBay in the Eastern District of Virginia in 2001. They proved infringement. There was the jury found the patent was the one patent was valid and infringed, and Merck Exchange asked the district judge for a permanent injunction enjoining eBay and their buy it now feature. The district judge in the case denied that request, despite the general rule that an injunction will issue. Denied the request and said, well, Merck Exchange, you have tried to license this patent before. In fact, you tried to license it to eBay, and you also don't practice the patent, and you waited to seek a permanent injunction. You didn't seek a preliminary injunction at the beginning of the case. You waited, you sought to seek the permanent injunction. Those three factors, I think, really weigh against your argument that you would be irreparably harmed by a permanent injunction and denied that request. Merck Exchange appealed that decision to the Federal Circuit. The Federal Circuit reversed and said, no, under this general rule, absent exceptional circumstances, and we don't see any exceptional circumstances here, you get your permanent injunction. eBay appealed, and the Supreme Court reversed. And Justice Thomas predictably took the centrist view and said that there's nothing special about the Patent Act when you're looking at equitable relief. And so you must apply that four-factor test that is applicable in all cases of permanent injunction. You must prove that you have suffered irreparable injury. You must prove that your remedies at law, in other words, your money damages are inadequate to compensate you. You must prove that the balance of hardship warrants an equitable remedy, and that there's nothing in the public interest that would be disturbed by a permanent injunction. Excuse me. In reaching the opinion, Justice Thomas relied heavily on the language of Section 283 that states that injunctive relief may be granted in accordance with the principles of equity. And this was a big argument on eBay's part. eBay said, look, the statute says may be granted. It doesn't say shall be granted. It doesn't say shall be presumed. It says may be granted in accordance with the principles of equity. And that means it's in the discretion of the district court. The district court should have to apply the four-factor test and arrive at a decision as to whether equitable relief is appropriate. Merck Exchange argued, well, look, the essence of your patent rights is the right to exclude others. That's in Section 154. And that right to exclude justifies the general rule in favor of injunctive relief. Supreme Court rejected that. Thomas wrote, well, you're sort of confusing the creation of a right with the provisions that deal with a remedy. And this right is subject to the provisions of the title, which includes the may language of Section 283. So that this doesn't support the general rule in favor of permanent injunctive relief. Justice Thomas said basically, Federal Circuit, you went too far in finding a general presumption in favor of permanent injunctive relief. He also said the district court, you went too far. Because what the district court said was, well, your willingness to license and the fact that you don't practice the patent, that's enough to establish that you would not suffer irreparable harm. And Justice Thomas says, well, that's going too far the other way. There will be situations, or could be situations, where a patent holder decides that they don't want to license the patent, or they don't practice the patent. They use university researchers as an example, and said, there may be situations where this goes too far. There shouldn't be a general rule against people who don't practice their patents, patentees that don't practice their patents. And this, like I said, goes too far. So when you get through Justice Thomas's opinion, there's not much guidance going forward as to when you might be looking at a permanent injunction. There were two concurring opinions, though. One by Chief Justice Roberts and one by Justice Kennedy. And Chief Justice Roberts said, well, yes, I agree, you need to apply the four-factor test, but we're not working on a blank slate. We've got 100 years of decisions that apply the four-factor test, and you need to look at those decisions, district courts, when you are deciding whether or not you're going to grant injunctive relief. And he says a page of history is worth a volume of logic. Justice Kennedy's opinion said, well, that's true. You do need to look at historical cases, but we're not really dealing now with the typical historical case. And we're seeing cases in the courts that are not your typical disputes, so that you could rely on this historical precedent. I said three things that you need to look at, according to Justice Kennedy. You need to look at the nature of the patentee, you need to look at the nature of the patent, and the relationship between the inventive feature and the accused product. This is the shot at basically the non-practicing entity, subset of which I guess are known as the patent troll, the patent speculator, those entities that don't practice their patent. Justice Kennedy thinks you need to take that into consideration in determining whether injunctive relief should be granted. Small component of the product. Justice Kennedy wrote, this is the nature of the relationship of the patented feature with the accused product. When a patented invention is but a small component of the product, the company seek to produce, and the threat of an injunction is employed simply for undue leverage in negotiations, legal damages may be well sufficient to compensate for the infringement, and injunctive relief may not serve the public interest. You're going to see this in software cases in particular. And then finally, this tack on business method patents, where Justice Kennedy says, you got to look at the nature of the patent too. And with regard to business method patents, the potential vagueness and suspect validity of some of these patents may affect the calculus under the four-factor test. There are no courts that I'm aware of that have actually dealt with this issue. And there was some debate at the oral argument as to whether this is actually something that should be considered in considering the four-factor test. I mean, obviously, once you get to this point, you've got a jury verdict. They've already found the patent valid. So there's a debate about when this comes into play, if at all. So we've got, since May of 2006, when eBay came down, we have found 10 cases on the district court level that have applied eBay. And of those 10 cases, in 7 of them, injunctive relief was granted. I think that's, you probably could have predicted that. Justice Roberts' concurrence, and the fact that we're still looking at the patent right to exclude, and the difficulty in assessing monetary damages for that right to exclude. But if you look at those 10 cases, and 2 of them, I guess, where injunctive relief was denied, one of them actually, it was Judge Robinson in Delaware. She said, go back and find some more evidence and come back to me, and we'll discuss the eBay factors. But these are the things that you're going to have to look at and prove in your case, I think, based on what's come down so far. You know, is the infringing feature a small component of a larger product? All the cases that have come down so far address that. And the case, the 2 cases that denied injunctive relief, this was a big factor in the court's decision-making, and I would point you to Z4 versus Microsoft. Judge Davis in Tyler, Texas, actually denied permanent injunctive relief where the plaintiff was seeking an injunction against Windows XP, and the feature, the feature was a portion of that that operating system, obviously. Does the infringing product compete directly with the patentee's product? Every court that has addressed eBay since eBay deals with this issue, and not one has denied injunctive relief where there are competitors in the marketplace. Are the infringing sales eroding plaintiff's market share or damaging brand name recognition? Is there price erosion? All these are tied together. Has the patentee licensed the patent to others or offered a license to the accused infringer? This is not dispositive. In fact, you know, if you look at Justice Thomas's opinion, you know, this will not get you there, but it is a factor to consider. If there's been an offer for a license, if there are other licensees, the court can consider that in determining whether the court is going to grant injunctive relief. So the bottom line is these are the things that you need to keep in mind. The value of a patent is arguably affected, especially if your patentee is a non-practicing entity. Your chances of defeating a request for injunctive relief are much better today than they were a year ago in that situation where you're facing a non-practicing entity. You need to consider eBay when you're putting together, obviously, your proofs for your case. For instance, you know, the competition, market share, brand name recognition, price erosion. You might not have a case where you're seeking lost profits or price erosion theory damages, but you still might want to develop those issues for your injunctive relief argument. And the last thing that comes into play is forum. In light of eBay, well, in the last year and a half, I would say there's been a record number of complaints filed, for instance, the International Trade Commission. Some think that that is a result of eBay, because in the International Trade Commission, under a 337 investigation, you get an exclusion order. That is the remedy. You don't get damages, you get an exclusion order and a cease and desist order, and some think that the number of cases that have been filed at the ITC recently is related to the decision in eBay and the question or the uncertainty as to whether you're going to get an injunction now going forward. Thanks.
First of all, I wanted to thank the folks here at Duke Law School for inviting me to be here, and thank all of you for being here today and giving me this wonderful opportunity to talk to you about one of the cases that the Supreme Court has handed down this term, the MedImmune versus Genentech case, and I'm going to talk about three things pertaining to this case. First of all, what the Supreme Court did say in the case, and then what it didn't say, what it left open, and finally, potential patentee and licensee responses to the holding in this case. So first of all, what did the Supreme Court say? What is MedImmune versus Genentech about? This is a case in which MedImmune took out a license from Genentech that covered a product that MedImmune had previously been selling. MedImmune, when it took out the license, did so under protest because it protested that the patent that Genentech had that MedImmune was taking out a license for was not valid. However, MedImmune decided to take out the license and continue to pay licensing royalties rather than run the risk of an infringement suit and potentially willful infringement as well. And then MedImmune sought a declaratory judgment of invalidity of Genentech's patent. And then the question arose, well, does this create enough of a case or controversy, given that MedImmune is still paying out its licensing royalties for a declaratory judgment action to lie? So 8-1, the Supreme Court said that a licensee does not have to breach its license in order to have standing to sue, in order to have enough of a case or controversy to challenge the patent in the courts. The one dissenting justice, Justice Thomas, said that because the licensee in this case, MedImmune, had voluntarily entered into this license and was continuing to pay it, and it had not breached its license, there was not enough of a case or controversy to justify declaratory judgment action to lie. What MedImmune does, what the Supreme Court did, was throw out the Federal Circuit's previous test for determining whether or not there was a case or controversy in this kind of circumstance for declaratory judgment relief. Prior to this, in the GenProbe case, the Federal Circuit had laid out a two-part test and said there has to be, in order for declaratory relief to be granted, first of all, quote, an explicit threat or other action by the patentee which creates a reasonable apprehension on the part of the declaratory judgment plaintiff that it will face an infringement suit. So there's got to be a threat of suit, end quote. And prong two, the licensee has to be engaged in some sort of present ongoing activity that could constitute infringement, or has to have taken some sort of concrete steps that could be construed as the intent to conduct infringing activity. The Supreme Court essentially eviscerates that two-prong standard, throws that test out in MedImmune, and replaces it with a simpler standard that says the declaratory judgment plaintiff has to show that there is a substantial, quote, substantial controversy between parties having adverse legal interests of sufficient immediacy and reality to warrant the issuance of a declaratory judgment. So gone is the two-prong test, and now there's the existence of a substantial controversy between parties having adverse interests test. Now, what sort of repercussions is this going to have? Obviously, this is going to influence the way that patentees write and structure their licenses. It's going to have repercussions for licensees as well, and it's going to have repercussions beyond patentees and licensees to the question of generic drug companies who are seeking FDA approval for their generic drugs as they go through the ANDA process. Because if a pharmaceutical company with a patent on an existing drug chooses not to sue a generic drug company that has informed the FDA that they plan on marketing a drug, and if the patentee chooses not to sue, can the generic drug company challenge the validity of the existing patent, even if they are not themselves engaging in activity that could be construed as a violation of that patent. MedImmune versus Genentech suggests that, yes, it's much more likely that this could occur, so this is something on the thumb on the scale in favor of generic drug companies as they're going through the drug approval process. So the Federal Circuit is going to be left with the task of trying to figure out exactly what this new standard means, exactly what a substantial controversy between parties having adverse legal interests is in the case of licensees taking out licenses from patentees and then challenging the validity of the patent without breaching the license. So that's what the Supreme Court said, but what is equally important is what it did not say, because it was not before the Supreme Court, and that is, what do we do about various clauses that patentees and licensees could write into their contract to try to contract around MedImmune, try to contract around this particular problem? Now notice what the core problem is with these licenses. Every patent granted has a presumption of validity, but there's still always the chance that a challenged patent could be struck down and declared invalid if challenged. Both patentees and potential licensees know this before they go into a licensing negotiation. And so we can expect that if the two sides are smart about structuring the license, the licensing royalty rate is going to reflect, to some degree, this uncertainty about the validity of the patent. The greater the uncertainty about the validity of the patent, the more we would expect that to be built into the licensing rate, and the greater a discount we could expect that the licensee would get. So now, post-MedImmune, licensees can protect themselves from a willful infringement suit by taking out a license, but what happens to that discount? So I'm proposing, or I'm suggesting that we would expect parties to, or licensees, not to get so great a discount if now they can turn around and sue patentees for the invalidity of the patent. Let me give you three possible clauses that patentees or licensees might want to put into the licensing arrangement, and just see what the results of these three possible hypothetical clauses could be. One clause could be something along the lines of a phrase that says, the parties understand that there's always some risk that a patent may be invalid or construed not to cover the product. And in light of this, in consideration for a royalty rate of, let's take a number out of the air, 3%, the licensee promises, Clause A, that it will not contest the validity of the patent. Now, MedImmune doesn't tell us anything about this one way or another. I'm going to go out on a limb a little bit and say, post-Lear, this is going to be a non-starter. Courts are not going to allow this kind of contractual provision to be upheld, although that ultimately remains to be seen. But I'm fairly confident in saying that licensees could not have upheld a clause in which they agreed not to challenge the validity of a patent. Is there another way, though, that parties could contract around MedImmune that could be upheld? Consider option 2. Once again, in exchange for a royalty rate of 3%, the parties agree that if the licensee contests the validity of the patent, then the patentee reserves the right to terminate the license immediately and bring an infringement action and request injunctive relief. Now, if this kind of clause is going to be upheld, the parties have just contracted around MedImmune, and they've gone back to a pre-MedImmune state of the world. Now, consider option 3. Suppose instead that the parties wrote a clause into their license that says, in exchange for consideration of a 3% royalty rate, the parties agree that if the licensee contests the validity of the patent and the patent is found to be valid, then the licensee will pay a 6% royalty rate. Now notice that until the validity of the patent is questioned, the licensee is essentially getting a discount in its licensing rate because that reflects the uncertainty behind the validity of the patent. And so if a licensee tests that and the patent is found to be valid, could the parties build in a higher royalty rate that the licensee would then have to pay? Something like that, I think, would be very likely to be upheld as a matter of contract law. The problem I see there, which didn't come up in my hypothetical of 3% versus 6%, but depending upon the percentages that one selected, you could run into questions of whether this was merely a liquidated damages clause or whether this was a penalty clause, and so therefore void under public policy for being too great a penalty imposed on licensees for exerting their legal rights. So those are questions that arise addressing issues of what the Supreme Court didn't say about clauses that parties might put into their contracts to try to get around the declaratory judgment problem that arises in MedImmune. Well, what sort of results could we predict going forward? What sort of things might we expect to see? What might parties do? I'm going to predict that parties could do a number of things post-MedImmune, and here are some things we should expect to see. If patentees now know that they can't inoculate themselves from an invalidity suit by getting a licensee to take out a license, we can expect that patentees will expect licensees to raise challenges more often, and therefore licensing rates will go up. Licensees won't get that discounted rate that reflects as much the uncertainty in the validity of the patent. Another thing we could expect patentees to do is to start to demand more lump sum payments, payment up front of licensing fees before the patent is declared invalid, as opposed to licensing fees being spread out over the term of the entire patent. What is this going to do for industry structure? It makes it just a little bit more difficult for small companies to become big companies because now they have to come up with larger fees up front instead of being able to pay the fees in an amortizable fashion. We could also expect that this creates incentives for patentees to vertically integrate and keep their products within the company as opposed to licensing them out. Now that a license does not buy you an inoculation against a patent challenge, and most economists and most of the empirical literature on innovation agrees that vertical integration is just not as effective in getting products to market and allowing innovation to occur as disaggregation is and licensing is. And finally, we could expect that patentees would be much more careful about who they would license to. And it's possible that we could see licensees that develop a reputation for challenging patents finding it difficult to be able to get licenses, sort of like tenants in New York City who sue their landlords. Whenever you move into a new apartment, you have to get letters of recommendation from all of your former landlords, and if you've had a landlord-tenant dispute in the past, which fortunately I have not, you'll find it very difficult to find a new landlord who will rent to you. The same sort of thing might happen with licensees who develop reputations for being willing to sue patentees. After this happens once or twice, future patentees may not want to give license to these licensees at all. So these are some possible outcomes that might occur, and I'm looking forward to your comments and questions in the question and answer period. Thank you.
My name is Dennis Crouch. If you get tired in this speech, this is the last one, so you should be writing down some questions to pepper us with, or remarks about how we're wrong. You know, let me see if this works. So this is the globe, the Earth. International patent law is a very large topic, and I'm not going to cover that by any means today. The way that I'm narrowing it down is talking about international patent law, but from the perspective of what you can do inside the U.S. courts. There's a couple of things I want you to take away from today's talk. Besides, we're going to talk about 3 different cases, but general principles. You know, there's a lot of people believe that the Federal Circuit is fairly pro-patent, and that's true insofar as you don't see the Federal Circuit in their opinions writing sweeping statements like Kennedy did in the eBay opinion. But at least on the international scale, it doesn't look like the Federal Circuit is really a jurisdiction monger. They're both expanding, but at other times resisting expanding. So they go both ways from that perspective. The second point that you should take away, though, is that there are ways to capture foreign activities and damages for foreign activities while sitting here in the U.S. and filing lawsuits in U.S. courts. Now, traditionally, patent law is quite territorial and follows these political boundaries. So you can obtain a U.S. patent, a Canadian patent, a patent in the U.K., a patent in France and Germany, and all of those are different patent rights. This case that recently came out called Voda v. Cordis, a doctor, a cardiologist, I think he's a cardiologist, some type of MD in Oklahoma. Let's see if this works. Oh, yeah. So I'm going to focus here on Oklahoma. So this is a picture from his patent. It's some sort of catheter that goes up through some tube in the human body and helps you with medical procedures. So this man, Dr. Voda, obtained a patent in the U.S. He also thought that this was going to be quite valuable property, and he also applied and obtained for patents all around the world, in many different countries, including several European countries. And he saw this bad guy, Cordis, come around and start, using his product all over the world. And so Voda was upset. Voda's just this simple doctor, though, and doesn't have an international operation. So what Voda decided to do was, he said, well, why don't I just ask the U.S. court to make a judgment on all these patents at once? And the U.S. court agreed. And essentially all of these patents, I believe, stemmed from the same invention, and in fact stemmed from the same initial filing in the U.S. And these are just branches, and the differences may be slight differences in the claim language, and some of them might be written in another language, but that's just because they were translated. They're certainly derivative works under copyright law. And so under what you learned in civil procedure of the concept of supplemental jurisdiction, even if the federal court doesn't have original jurisdiction in a subject matter, it can adjudge concepts of foreign law, and that includes law of individual states as well as from other countries under this concept of supplemental jurisdiction, and that's what the district court did. And the case was appealed on a writ of mandamus, which means it immediately went up to appeal. Interestingly, the lower court continued with its process and decided the U.S. cases even before the Federal Circuit decided what it did. But Federal Circuit came down and came out with a fairly clear rule that this is not allowed. So the takeaway from Voda, if you're a practicing litigator, is you're not going to be able to sue someone right now on a Canadian patent in the U.S. court. Now, the Federal Circuit made several bits of reasoning, and some of them I follow, some of them I don't follow. But from my perspective, there is a very long and extensive history of international treaties in intellectual property and in patent law. And from my perspective, it appears almost like those treaties occupy the scope of this type of activity. And all, at the underlying nature of all those treaties, there's the idea that patents are territorial and enforcement is national. So I think this, from that reason, is a good decision. And the interesting thing that the court left open is that we might change norms of international law. There might be new treaties. We could decide that there may be a treaty between an extension of NAFTA that says we can also enforce a patent in any country, or some other way of extensively harmonizing the laws of North American patent law that might change the court's result. But barring that change in international law, Voda v. Cordes shuts down suing on international patents. Now, the second case I'm going to talk about is Research in Motion that settled last year before coming to an injunction, and it was big news on Wall Street just because it settled for several $100 million. And in fact, this is an interesting phenomena that's going on in patent law, and there are a number of hedge funds that are making lots of money now on patent lawsuits, following them closely. And every day when any news came out about this case, you could actually see the stock prices swinging quite wildly. But the notion of territoriality comes in play in the patent statute, and it's very notable in the infringement portion of the statute, section 271, and I have the text of 271A that says that when you make or use someone else's patent within the U.S., that's infringement. Now, what's happening in this case? This is a image from, I believe it's from Research in Motion's brief that they filed. In this case, Research in Motion is a Canadian company, and they were operating out of near Toronto. I think it's Waterloo, Canada, and they have all of their relays and switches. These are some sort of large computers sitting up there in Canada. And then they also have operations in the US. But whenever anyone uses a BlackBerry to send an email, it apparently, according to the briefs, goes to Canada and comes back to the US. And so there's a very clear argument on their behalf. They said, we don't infringe. There's no way we infringe because we're not using your invention in the U.S. We're using a little bit here, but we're not using the invention because that means the whole invention. And we're using part of it abroad. And in fact, the patent holder, NTP, an important part of the claims involved what was going on at the relay. So it wasn't just some trivial aspect being thrown abroad, but it was an important aspect that was over there. Well, it's the outcome of the case, the kind of rule that, what happened there? Oh yeah, here we go. The rule from the case is an interesting one and an important rule for anyone prosecuting patents. The rule said, if you have a method claims, such as a method for sending email that comprises typing in an email or receiving typed instructions, sending them to a relay, and then sending them to a recipient. The court said each step has to be performed within the U.S. On the other side, if there's a system claim, a system for sending email, including 2 handheld devices and a router, all of the parts don't have to be within the U.S. It's a matter of what is the location of the control and beneficial use? I should have put that in quotes because control and beneficial use are the code words there. And because attorneys and stockbrokers are all using and controlling their BlackBerry devices in the US, the court said the US is the location of the systems. And so this decision ended up wiping out about half of NTP's claims because half of them were system claims, half of them were method claims, but the other half were system claims. And so they, and if you're the patentee, all you need is one good claim and you can get your damages. I think there's a good defense of this case simply because it's so easy these days in the world of electronics for someone to place a server abroad just to avoid infringement. And so there is arguably some need to capture transnational systems. Although on the other side of that, I think that also a good, a careful patent drafter can avoid most of these problems. And we can talk about the doctrinal defense of this during the question and answer if you want to. The last thing I want to move to is Microsoft v. AT&T, which was just argued this week. And Microsoft v. AT&T, I think I have another. So Microsoft, we all know, makes software. That's supposed to be over in Washington. And in this case, it involved Microsoft creating its software, sending the software abroad to some foreign country, including some European countries. Once it gets abroad, making a number of copies of the software, and then installing those copies into computers. Now, AT&T has a patent that covers the software installed on a computer. Okay? So the software itself is not infringing. It's only infringing once it gets installed on the computer. And so typically, this is a clear case that it's not installed on a computer in the US. Therefore, it's not infringement under 271A. But there's an additional statute that's further down in 271 called 271F. And there's part 1 and 2. And here I have part 2. But 271F talks about the supply of a component of a patented invention and intending that component will be combined to form an infringing, what would be an infringing, in an infringing manner abroad. And AT&T said that's exactly what's happening here. Our patent calls for software installed on a computer. Software is shipped from the US abroad and then installed on that computer. So that component, that software component, is shipped abroad and installed on the computer. And the court agreed. We don't know the exact damages in this case, but Microsoft just lost another case on this same topic yesterday, and the damages in that case against the French company that bought Lucent, that I think Alcatel, in that case, Microsoft just lost a jury verdict for $1.5 billion with a B, and half of those damages are for this extraterritorial infringement. And there's another earlier case that was for $500 million, where also over half of them were for the outside damages. So this ends up being very big, and especially in the software area, because it's so hard to get software type patents in the rest of the world. This becomes a major way for people to try to recapture that. Now, the Supreme Court is deciding this case on and there's really two issues presented, and I'm out of time, but the two issues presented to the court are, can the software be a component? Because the idea and the purpose of the statute when it was written, everyone thought that component meant something tangible. And software alone is not tangible. So I've called this the tangibility requirement. And that's something the Supreme Court's deciding. And the second issue is, were the foreign copies actually supplied from the US? Because if you remember, software was supplied and then copies were made and then installed. And so it's not actually what was shipped that is installed in the computers, but it's copies of software. And so there's a question of if they're actual different molecules that go into the final product, does that, and they actually, those are my words of molecularity, but that's how I interpret the case. But we'll know in about 3 months what the court decides, maybe 4. So I'll stop for now.
So the presenters have raised some terrific questions for all of us. What we're going to do is take a 10-minute break, get back, well, 7 minutes now, by 10:45. 2 announcements. First, anyone who is attending for CLE credit and won't be here for the entire symposium needs to fill out a partial CLE credit form. That's 1. And 2, the programs are here if you want a program. So let's all return at 10:45 for a moderated discussion with our panelists.
Yeah.
Wonderful panelists to whom you can direct questions. I thought I would just prime the pump a little bit because I got so excited when I was listening to them. And there were 2 questions that occurred to me. One, a kind of deliberately provocative question suggesting that John Duffy and Steve Gardner are at loggerheads or have completely disparate perspectives on how patent law should be governed. Steve Gardner, I think fair to say that he likes the idea of rules that will help you, for example, determine what a claim term means because you can look to a particular dictionary. And you even suggested that if we could do that en banc, that would be really nice. John Duffy suggesting that courts should be looking at the substance of the invention, the history. And my question, which I've sort of leaked already to them so they have a little bit of preparation, is I've observed that most patent lawyers in practice like rules. I would say, and this is not a hard and fast statement, but in most patent professors, not all by any stretch, tend to think that rules at a certain point run out, that at some point you will need more totality of the circumstances or looking into history, that rules at a certain point become empty formalisms, as a typical law professor might say. And why is that? Comments from Duffy and Gardner, and then perhaps the other the panelists would like to comment as well.
Okay, I'll start out. Arti, that's an excellent question. And in fact, I thought as Steve was giving his talk, I was writing down and saying, this really is exactly the opposite of what I'm thinking. So I think, it's, Steve, I'm sure you're a nice guy and I'm sure we agree on a lot of things, but I think the sort of hope to have an en banc that will give us rules is really just illusory. Especially when you think about patents lasting for 20 years, and you have to actually write your claims and sort of write your application to sort of anticipate to some degree what's going to happen in the future. And just within the last 10 years, it seems like we've had 3 or 4 different sets of en banc rules from the Federal Circuit about how to do claim interpretation, or so sort of wild swings. We've had Markman, we've had dictionaries. Now we have Phillips with perhaps more dictionaries. And, I'm going to try and make trouble and say there should be a different approach to claim interpretation. So I think that the idea that we're going to have a set of rules, and those are going to be hardy in the sense that they will remain the golden rules for even a 20-year period, I think, is illusory. And actually, and this will be I promise, my last comment, you actually said that some of the examples you gave are examples where the Federal Circuit is pushing the law in my direction. And I could not disagree more in some ways. I mean, it is true that those were narrowing the claim language according to the specification, but that gave me absolutely no security that that was the right thing to do with those patents. Indeed, the example, which I didn't get to, but I urge you to read, is the Judge Hand's treatment of the Wright brothers patent, which actually had this huge problem in it, which was that they had a certain system for stabilizing an aircraft. And one of the key features that they thought was inventive was that they had this pulley system to make sure that when they warped the wing in one direction, they had to move the rudder in the opposite direction to maintain lateral stability on the aircraft. It turns out that after people learned how to fly, they realized you didn't really need this pulley system. All you needed was to have a pilot who could control both surfaces. And because the pilot now knew how to fly, because he was taught by the Wright brothers, the pilot could essentially make sure that when he warped one side, he'd push the rudder in the other direction. And Judge Hand said, well, this patent says a means for making sure these two actions happen simultaneously. And in the Wright brothers, it was a pulley system and a cable system. But now it's a pilot. But that's equivalent because this is a pioneering patent. The Wright brothers taught people about this. So the pilot is still using the Wright brothers technology. And we'll take that broad interpretation. He admitted it's a broad interpretation because it's a pioneering patent. So some of the examples you gave me, the thing that was missing was invention. What were each of these things, what was their advance in the art? And you can't tell just because they've given examples of a fuel filter versus a fuel injection component. I don't know what that patent was all about. So that's where I think actually, at least my view about losing invention actually has some traction, and where Judge Hand's opinion would actually look at invention and use invention as the pole star for interpreting the patent, sometimes broad, sometimes narrow. And that's what I think we're missing. And I think those examples are good examples of what I'm complaining about. I'm not trying to be hostile to patents. I'm trying to be fair to patents. And that sometimes means interpreting them very broadly.
I think the main difference in the interest in rules, I think, is clients. I have client and explaining to a client what they can expect and how to go about procuring patents that will protect their innovations. They and I want to know how to do that. If you tell me what the rules are, I'll win. And the difficulty, one of the main difficulties with carrying out my job and to furthering my client's interest is looking at the body of case law and saying, okay, well, in this situation, because the specification described multiple embodiments, that will enable those embodiments to fall within the scope of the claim. But in this case, like the Honeywell case that I didn't talk about today, you described, they described two embodiments, steel and carbon, and compared them against each other. And because the steel always won, the Federal Circuit said, well, carbon had been demeaned. Carbon had been described as not as good as steel, so we're just going to interpret the claim to mean steel. And reconciling the rules on how to go about drafting patents and how to go about litigating patents in a way that you can tell your client, here's the probable result, here's what you should be thinking about, it's very difficult without a good set of rules. And if there's not, we just burn money. We burn money and time in trying to carry out the protection of innovation and trying to protect the investments that a client has made. I do look at claims differently, and I may be misinterpreting, so you correct me. I do look at claims as the statement about what the inventor views as his or her invention, And then the claim interpretation function is a function of determining, well, what is it? How is that defined? I don't view the claim interpretation function as determining, what is it that is ultimately the great advance here. To me, that gets more into a question of, well, the inventor has said what the inventor thinks he or she should be able to exclude others from doing, but is that correct? Is that a valid claim? And I see those sorts of questions falling more into the the validity question. And then just the third thing, I do see those opinions that I've described. My interpretation of those were that the Federal Circuit did try to do what you were asking of them. They did try to look at what is it that's really the invention here. Like in the on-demand machine case that I mentioned, customer. It would have been much easier to say customer means customer. Customer means what you think it normally, ordinary meaning. But instead, what the court did was, took a really hard look at the specification and to see what's the advancement, here, and what was the focus. And in that case, it was, a situation where you walked up, to a device in a retail shop, selected a book that you wanted, pressed the button, out popped the book, a single copy of the book, direct retail. And I think the court looked at that and said, well, no, we're not talking, the scope should not be just any old customer. It should be the advance, what the invention really was this particular customer using this particular device. So I think that's some of the places that we cross there.
I think Dennis also wanted to speak, and Ron and Clarisa, you should feel free to, particularly because in the case of Ron, the eBay decision took what was formerly a fairly bright line rule from the Federal Circuit and turned it into a multi-factor standard. So.
I think that's what I was going to mention, is that the same debate is in a large part, I think you can see that playing out between the Federal Circuit and the Supreme Court, where the Federal Circuit tends to be much more rule-based. And so we saw that in the eBay case where the Federal Circuit rule was if you win the case, you get an injunction. If the patent is valid and infringed, you get an injunction. And then the Supreme Court said, no, not so fast. We should analyze these factors. And it should be able to go either way. And then also with the MedImmune case, the Federal Circuit said they had a bright line rule. If you're a licensee in good standing, you can't sue for declaratory judgment. And the Supreme Court said, well, wait, not so fast. We need to make this a bit more flexible. And we'll see in the next couple of weeks that the Federal Circuit had a very hard and fast rule on obviousness. And the Supreme Court will say, no, not so fast. We need to be flexible on this.
I'm hoping you're right on that one.
We'll see.
Ron and Clarisa, do you agree with that sort of interpretation? It's a rule of standards, to some extent anyway, kind of dichotomy?
Yeah, and I think Dennis put it as well as I could, so I'm going to defer to.
But you seem to favor the rule in this case.
Well, actually, I like the result in MedImmune, but what I wanted to do just for my own intellectual fun is to try to think of all the terrible, awful things that could happen as a result of MedImmune and present that to. So I came across as very much more pessimistic about MedImmune than I actually feel, and I hope that some of you will take me up on that and challenge me.
And I prefer, Steve, Steve's view, you've got to have predictability, and I would take predictability over unpredictability.
So this is just beautiful. The academics all like standards, maybe the lawyers all like
We have
rules.
a rule that we all like standards.
That's right, that's
It's
right.
important not to confuse predictability with rules.
Okay.
I mean, rules could be unpredictable too, particularly if they're changed rather rapidly.
Good. And then the other question that I had, and we should open it up after this, is perhaps for Ron and Clarisa, in that the consequence of both MedImmune and, to some extent, eBay, although perhaps less so, or less directly, because you have to kind of think about what the interim threat of preliminary injunctive relief might be for certain people who want to challenge patents, is obviously it's more likely that at least some patents are going to be challenged. And Is that the argument that could be made, and I didn't know, Clarisa, that you were just playing devil's advocate, so I will make it thinking that I'm challenging you, is that to the extent that there is, and Lear talked about that there's a public good element to having bad patents invalidated, and there's been a lot of discussion of the reasons why. If you're going to invalidate a patent, generally speaking, your incentives are not going to be as high as they should be because you're invalidating it for all your competitors as well. Is this good because it'll help us, it'll maybe mitigate some of the public good problems associated with patent challenges?
I think on the one hand, it's a good thing to have, or there are good things that come out of having a system where issued patents are easier to challenge. One of the things that I'm curious about is how this is going to affect the balance of power between the PTO and the courts in terms of which mechanism that parties would choose to challenge issued patents. And I think it would shift the balance of power a little bit away from the PTO and more toward the courts, because it becomes easier to challenge a patent, and you can you challenge it on a much broader basis after MedImmune through the courts than you could through the PTO re-exam procedures. So that's one outcome that I see. I think on balance, it's a pro-competitive result. MedImmune is. I mean, I agree with you that I think it's some licensees would hesitate to challenge a patent and thereby do their competitors a favor. And I'm wondering how much behind-the-scenes negotiation is going to go on between licensees and patentees as they negotiate to get a reduced rate in exchange for foregoing specific patent challenges.
Ron, did you have anything you wanted to add? All right, so let's open up. As usual, a professor has his hand up first. Professor Reichman, has the floor.
Well, I thought there were excellent presentations and a beautifully organized program. I have 3 or 4 different questions for different ones among you. Regarding Professor Crouch, it seems to me there's some tension in what you described between, on the one hand, disrupting the patent policies of other jurisdictions on issues that are unsettled in international law. So a huge brouhaha about software patents. Right. And now you're going to make people pay for violating patents that are invalid in the countries where they violate them. This is going pretty far. But on the other hand, and I was comforted by a similar sentiment by an ex-student of mine who happens to be here today, on the issue of supplemental jurisdiction, you're sort of ignoring international norms. You got a lot of international norms. You got the same case in 10 jurisdictions, the same facts. Right. Why can't you consolidate? Rochelle is convincing me that maybe we ought to consolidate more. So I'm curious about your thoughts there. For Mr. Rabis, on the eBay, the small component aspect of eBay, if it's a small component, maybe you should not give the injunction. Isn't this sort of a backdoor and a poorly worked out approach to a much larger question, a de facto compulsory license for dependent patents, which is perfectly legitimate under the TRIPS agreement 31L, and most countries have it? Wouldn't we be better off with having the availability of a compulsory license for dependent patents? And also, I wondered if you would comment on Jorge Washington's view that eBay may be very important in blocking in research patents that can harm research in biotech. And on the issue of claim construction, I think that's Mr. Gardner. The trend that you described is really, if I understand it correctly, purpose-driven claim construction. And my question is, why should there ever have been anything else in the Federal Circuit? Why should you ever be able to claim for future unknown uses? And for Clarisa, just based on what you just said, well, will you go so far as to support post-grant opposition, which seems to follow logically from where you were headed?
All right, I'll start.
Don't you have anything for John?
No. I feel left out. But so I knew as I was speaking that I was speaking loosely with my presentation, because in fact 271F does not actually require any foreign activity. And so the first response is kind of doctrinal in that 271F requires export with intent to combine it abroad. And so from a doctrinal standpoint, the courts can easily say we're not stepping on any foreign toes because we're just looking at what happens at our borders. And if someone is doing it with intent, then that's enough. And it's actually, according to the wording of the statute, it never has to actually be combined abroad in order to be infringing. It just has to be exported with the intent. Now, the second aspect of that is that, there are large anti-software lobbying groups who are, and many of these are made up of computer programmers and many small companies and many large companies. And I think you'll be unlikely to hear any foreign developers who are really complaining about this decision. Because if you're a software developer in France, then you're happy Microsoft is getting blocked from exporting from the US, which improves your position in France because you'll never be sued on a US patent if you're sitting in France and developing software in France. And the only time you would ever get sued is if you actually import it into the US. And so I think there's not going to be any political brouhaha because and kind of the economists who have weighed in, who I think are somewhat predisposed to be anti-patent, but the economic analysis that's been presented is that the sum of AT&T's position of collecting for these exportation damages is that it pushes companies to move software development abroad, which most countries like.
But it could hurt foreign consumers who actually buy the.
Right.
That's
so
right.
it would
That's
help
right.
producers, but not consumers.
That's right. That's right.
Professor, I'm sorry I couldn't write fast enough to get you all your questions down. Could you? Yes.
On eBay, it could assume a very important aspect. And it seems to me that what you're really talking about, if you have a small component, what you're really saying is you've got a dependent patent, a blocking situation, and you're trying to deal with it. Well, okay, let it go, let them pay, rather than block the use of that small component. But the front door approach to that much larger issue is what do we do with blocking patents? And in my view, the better solution is to have on the books a compulsory license for dependent patents and use it so people know that they're going to have to negotiate around a blocking patent. And I'm told this happens every day in Italy where there is fear that people will actually seek to use these blocking patents. And the TRIPS agreement allows you to do it, 31L. So wouldn't it be better to just go to formalize the position of blocking patents?
Sure, I agree. I think, but when you look at Justice Kennedy's concurrence, I don't think he's drawing a hard and fast rule on the small component. He's saying the small component of a larger system is something that you need to consider when you're considering the four-factor test. And so when you have a patent like in the Z4 Microsoft case that went to a very small portion of the Windows operating system, that's something that you need to take into consideration in the four-factor test. Compulsory license, very funny, came up in the discussion during eBay, and eBay sort of sidestepped the compulsory license question and said, well, we're not talking about compulsory license here because we've designed around already. And so we're not getting a compulsory license, we're not practicing the patent anymore, and sort of that ended that discussion.
Okay. With respect to your question, Professor Reichman, about whether or not I would support post-grant opposition, I think I definitely would for a couple of reasons, but I also want to point out a couple of caveats or concerns that I have. Some of the reasons that I would support post-grant opposition are that there have been times in this country's history when it has been too easy to challenge a patent, but this is not one of them. The PTO is issuing patents at a record rate, and just with the time constraints that examiners are under to issue patents, there are a lot of bad patents being drafted and being issued, and the more that we can challenge bad patent drafting, the better off we'll be. So one concern of mine is to try to weed out bad patents from the system, and coming up with new mechanisms and increasing the ability of people to challenge existing patents is a good way of going about doing that. It's cheaper than litigation if you can go through the PTO route rather than having to go through courts. And I think it creates the right incentives for patentees to devote a little more time and effort and energy up front to writing the patent well to begin with. This is something that I've been, among the attorneys I've talked to, the patent prosecutors I've talked to, in somewhere between a minority and an extreme minority on this, but ever since my days of patent prosecuting, I've always thought that companies ought to invest a lot more time, energy, and effort getting it right up front and writing the patent well to begin with. Before it's, as it's going through the PTO, before it actually issues. And the reason I'm in a minority on that is because I hear over and over again, well, we're patenting so many things and we're patenting in bulk, and the chances of any of these things ever actually being challenged is very small, so why bother to pay your patent prosecutors a lot more up front when we can just deal with it out the back end in the 1 or 2 or 3% chance that these things ever get challenged, then we'll deal with bad claim drafting then. And my personal preference is to deal with the problems up front, because I, perhaps more than a lot of than other people in academia, think that patents have communicative value, and they are potentially, at least in the sector that I worked, which was biotech startups, we read everybody else's patents. We studied everybody else's patents. We studied their trajectory. And when you wrote patents, you wrote them in certain ways to try to throw off your competitors. Oh, don't mention so-and-so's product because we don't want inventors to think that this competitor's product is going to be valuable. So, so be sure not to mention that. You were very careful about who you cited and who you didn't cite. And I'd like to see more time, energy, and effort being put into writing the patent well in a good communicative fashion to begin with. The caveat that I have, the concern that I have, is by creating a new mechanism that allows people to challenge patents through the PTO, you have to reflect on the PTO Federal Circuit balance of power. And I've been looking at the PTO's balance of power, its relative power over the past. I would peg it starting in 1994. Since 1994, the PTO has increased in power remarkably. And again, I'll be a little bit of a minority voice here and say I really admire the PTO. A lot of people criticize the PTO. I look at the glass being half full, and I say, given the resources it has, it actually does a pretty decent job, considering the time constraints and the budget constraints that it's under. And that's a little odd for me. I'm not used to being an optimist, but this time around I'm going to be an optimist. And I really, in a sort of Machiavellian way, have to admire the maneuvering and the politicking that the PTO has done since 1994, because in that time it's gotten independence and it's increased its own governance power. Just last week, I was reading about how Congress ended diversion of user fees, which is big for the PTO. The budget of the PTO has increased enormously. They're now, they have their own campus. They've moved into new buildings. This is a powerful, this is a lot of rise in power for what was previously an unpopular subpart of the Department of Commerce, all of this occurring since 1994, and that's just on the budgetary side. The PTO, of course, was able to get what I think is a pretty an expressive victory or a symbolic victory in Zerko when it was able to get court agency review of its factual decisions as opposed to court review. And if there's any one thing out there that can counterbalance the Federal Circuit, it's the PTO. So you don't, and I'd like to see a balance of power between the two. I don't want to see one so powerful that it's able to dominate the development of patent law. And I think right now we're reaching that balance of power between the PTO and the Federal Circuit. It used to be the Federal Circuit was much more powerful, and the PTO decade and a half ago was definitely not very powerful. And I think it's a good, healthy thing to get a little bit of rivalry between these two bodies. So I'm a little bit wary of anything that would tip the balance one way or the other, and it's just possible the new post-grant opposition mechanism might do that. I think it's unlikely that it would, but that is a concern that we would have to have.
And you asked why should one ever be able to claim future unknown uses of a product or process? The way the statute, the Patent Act is set up is what's required of an inventor in obtaining a patent is they are required to describe how to make and use their invention. And then they're required to, set forth definite claims describing what is it that they believe they have invented and have the right to exclude others from making. And sometimes it's the case that what they have invented is a particular use of a product or process. Other times, in fact, many times, what they have thought of is an example of the use of their product or process. Like, take an engineer who works for a consumer electronics company, say, that invents a ball bearing to use in an MP3 player or some other handheld device. What they have in mind, what that person has in mind, is their job, is their work, and they're thinking of that ball bearing in the form of a MP3 player and that use. But it turns out that ball bearing is highly useful in the automotive area, and when the lawyers get involved and work with the company and the engineer and look at, okay, this is what you're describing, but you realize that, okay, we don't have to limit your rights and your reward for spending the time and investing the money to invent. We don't have to limit that to the the exact color of ball bearing, the exact size. To figure out what you've really invented goes broader. It can be used in a variety of different ways. And so when claiming and helping the engineer and the company that employs the engineer claim what it is that they're entitled to, if that ball bearing is new and not obvious itself, regardless of use, we try to protect at that level and help that company reap the rewards of their investment and have a broad property right. Sometimes it's the case you look at it and say, this is the context you've thought of it. Your property right coincides with exactly the use that you've thought of, and so we have to, when we're claiming what property right we're entitled to, we have to limit that property right to the particular use.
Other questions? Yes, the man with the yellow tie back there. That would be you, yes.
What you just described when you're dealing with the inventor, at what point do you have to watch the line of becoming an inventor yourself?
The entire time.
Yeah. I mean, if you're going to start suggesting different uses and scenarios,
well, what you do
is that really the inventor's contribution, or is that your contribution?
What you do as a good patent attorney, you don't necessarily suggest the embodiments. You ask the questions. You ask, is there any other way to use this? You're describing the use of the MP3, player, for example. Is that the only way to use it? Oh no. This could be useful in lots of ways. And what you do as a good patent attorney is to draw that out of the inventor and to do the best you can to understand what is it that's new and non-obvious here. Is it this use, or is it something? Is it the ball bearing itself? And one could use it in lots of ways. And so then you go about your job of protecting that right, in the right way with the most knowledge.
Let's see, third row, blue shirt.
Me?
Yeah, everyone's wearing the same color ties and shirts and so forth.
I actually have a question for Professor Duffy about, I guess, the Wright brothers case and sort of his view on capturing the invention. It seems to me that, and I haven't read the opinion and I haven't read the claim, so I'm not really, I'm a little bit lacking some information, but it seems like what Judge Hand did was look at what the Wright brothers invented, this pulley system for connecting, it sounds like the rudder with the ailerons on an airplane, and said that solves this problem of instability of flight. They have this patent on connecting these two parts together to solve that problem. By expanding that to cover the pilot, it seems like you are not giving the Wright brothers the patent on this sort of limited way of solving the problem of instability, but rather you are expanding that to giving them sort of a patent on preventing instability in flight. You're giving a patent on this problem rather than the particular solution that they came up with. And I think, you know, it sounds like it was a means for claim. Sort of what's come since then is the interpretations under 112.6, which say you get what's in the patent specification plus its equivalence. Seems to me that it sort of is a way to prevent going from a simple cable pulley, maybe with gears or with a computer, to a person or something that's completely unrelated to what the actual invention was, which sounds like it wasn't all that good because it was quickly replaced by a pilot and rudder pedals.
Okay, there's a lot in that question, and I think it's a very important question. I chose the Wright brothers patent because I think what Judge Hand did was very dramatic and very pro-patent, very pro-patentee. In terms of what the Wright brothers invented, which of course is consistent with my own thesis, I should start with that. I don't think that they just invented a pulley system. They invented a stabilization system. That is what they taught the world how to stabilize an aircraft. The whole idea of having an aircraft and having heavier than air flight was old in the art. The problem was you could get a plane up for a second or two, and then it would immediately crash because people did not understand how to stabilize it. So Hand, walking through the technology, realized that that was the stabilization technique was what the Hands gave to the world, what the Wrights gave to the world. And you're right that the claim here, the claim language that he was interpreting was means whereby said rudder, which is the tail, is caused to present to the wind that side thereof nearest the side of the airplane having the smaller angle of incidence. In other words, the one where the wing flap has not been depressed, which has, because when you try and stabilize a plane, what you do is if you start tipping one way, you try and generate more lift by depressing that part of the wing. That unfortunately creates more drag, which will tend to skew the airplane this way. So you have to turn the rudder in the opposite direction to maintain lateral stability. It's very simple. It's very clear what the idea is. I can explain it to you in a few sentences, and then you know how to fly a plane. People did not know that before that. So taking this language and saying, and this is what Hand said in terms of, patent speak 21st century, he said, the pilot with, levers and controls over both of these surfaces, who knows that when he depresses this wing, he also has to control the rudder and push the tail surface in the opposite direction. That's doing the same thing. And he's taking advantage of the Wright brothers' invention. So it is very dramatic. It's very favorable to this particular person, but it's consistent with the scope of what they invented. And Hand, in other opinions, but I think also in this one too, sort of didn't have very much time for sort of all these formalisms about patentable subject matter. Like, you see this debate in Justice Breyer's dissenting opinion in LabCorp about, whatever we can do, we can't have anything patentable that might be going through the mind of a human. Well, the Wright brothers patent, as interpreted by Judge Hand, is a clear counterexample to that principle. And it's important to realize just how dramatic that is, so that the next time somebody brings up a patentable subject matter to the Supreme Court and Justice Breyer says, you can't have something going into the touching the mind of the human, you say, Justice Breyer, you're going against learned Hand and the Wright brothers. And if that's not what our patent system is about, rewarding the Wright brothers, and that somebody like Hand was just stupid, then there's something wrong with your theory. If that's what you think, then there may be something wrong with your theory. You should really rethink your theory at that point.
I'm just going to interject one point there because I can't resist, which is everything you say seems very compelling to me, John, except as you also well know, the Wright brothers patent as an economic matter was so broad that it might have caused some economic problems had it not been for compulsory licensing of that patent in World War I.
Well,
So
I
if
think
we think of patents as ultimately all about economics, is that the best interpretation?
Well, that's a whole nother debate. I will say that if you don't interpret it the way Hand did, it would have zero value. which seems to be the wrong reward for the Wright brothers. There's a possibility of saying, you know, they get zero, and there's actually another issue which if that had been interpreted against them, they also would have gotten zero value. So this is not a question between, you know, giving them a huge reward, which actually I think is what they deserve, and we could talk about the cross-licensing problem with Glenn Curtis and what happened in that. And part it was because, you know, the Wright brothers, they were great inventors, they were terrible businessmen. They were absolutely horrible at it. And this is absolutely clear. And what ultimately had to happen was you get the Curtiss-Wright Corporation, which is the merger between Wright's technology, which was good, and Curtiss's improvement patents, which were also necessary in order to make an economic plane. The reason that took so long is just because the Wrights were being stupid holdouts. If these were publicly held companies, there's a solution to the problem, right? If you got two publicly held companies that are being absolutely stupid and not compromising, what happens in a modern world is a hedge fund comes in and buys both of them and says, look, there's value that you're leaving here on the table, and I'm going to purchase both of you and merge you. Because that's the rational solution that increases the value of not only to society, but of both companies individually. But I'd love to have that discussion.
We will continue, but I mean, it does seem like you think that's an outlier situation because of the weird personality of the Wright brothers.
Yeah, and it's also something that it happens when you have really individuals in control of a company. I think actually the danger of this happening with a publicly controlled company may be less.
All right, right. All right, well, there's that patient fellow in the peach shirt.
I guess I have a question that sort of relates to what we spoke about at the very beginning, which is rules versus kind of the open-minded judgment of the court, and how it relates to the PTO. Professor Long mentioned a few minutes ago there are lots of bad patents granted. Is that something that the PTO can sort of address by maybe having a set of rules that are relatively small but relatively restrictive on the number of patents, thus eliminating some of the broader patents out there that kind of muddy the waters?
I think there are a couple of things that the PTO can do. I think you could have substantive reforms, you could have procedural reforms. And there are a couple of simple procedural reforms, one of which, you're free to disagree with me on this as I go off into my wild proposals, is raise the cost of getting patents. It's too cheap to get a patent. Raise the cost of getting patents, and you'll see a lot of the cheap, easy, bad patents go away. Get rid of the count system. Get rid of the internal mechanisms at the PTO that say that examiners can only spend a certain number of time looking at an application, and after that, you're looking at it, the examiner's looking at it on their own time, and they're not getting paid to take more. And I think the number of hours is something like 14 hours. It's less than two full working, 18 hours? 18 less than slightly more than 2 full working days from start to finish. For a lot of these patents, that's just simply not enough. I mean, that's a cheap, easy procedural reform. Although I will say then the question is, well, what do you do with shirking examiners, which is why the count system was installed to begin with. The count system is just a internal system that the PTO has of measuring examiner productivity. They have to generate a certain number of counts per quarter, and a count corresponds to various different actions and units of paperwork that they generate. And at the very least, reforming that, I think, would go a very long way toward getting rid of some bad patents. As to the rules and standards issue, the substantive reform, if anything, I think the PTO has even more desire for rules than the Federal Circuit. Sort of like the lower down you go, the more bright line rules you want to see, because you're dealing with a larger volume of patents coming through, and so if you can come up with rules, then it becomes easier to process this huge volume of things coming through. So I would expect to see the PTO being more rule-oriented, although at that level, that may not be a bad thing.
Other questions? Yes, the fellow in the white shirt.
I guess it's kind of directed at John Duffy. And one question I guess I have is to whether what you're proposing in some sense may be a move back toward central claiming. And
In
and
patent speak, I think you're right. I actually, I like the sort of loss of invention. I think it's a better title for a paper than central claiming, because then I've already limited my audience to patent attorneys. So, yes, but I know you got more of a question, but I agree to some extent.
Okay, yeah, and the kind of second part is, I guess it's a broader thought in the Federal Circuit that it's been addressed so far in terms of a move toward rules, but I was thinking of something like inequitable conduct, where I think most people would argue in the last several years we've moved utterly away from any kind of clear rules at all, to the point where it's, I think of the Cargill case that came out last week, it's very difficult to know what someone is to even do in answering. In that case, it was an inherency rejection that the patentee had received. And then is being charged with inequitable conduct for not having addressed an obviousness rejection that was never issued. And so it is what the court perhaps is saying is really asking patent lawyers to stop thinking like scientists and to stop interacting with examiners like scientists, throw your technical backgrounds out the window, and start acting like corporate lawyers. And it is, anyone can answer that, I guess, but.
Well, I'll take a first crack at it. First of all, on the central claiming issue, I think that's part of it, but I actually think this theme is much broader about sort of losing invention. And in fact, actually, I was going to do three things. I really didn't even get to patentable subject matter, but if I had a fourth one, it would have been inequitable conduct. Because I think that is an area where we actually are heavily rule-based, heavily standards-based, and I think it is unpredictable. And I'm not really, I don't know if I'm trying to make a case for standards in all areas. I think that rules might be good in some areas. I was actually trying to make a list of them in jurisdiction and contracting. I actually have a lot of sympathy for the Chief Justice's opinion in the eBay case. I actually had a certain sympathy for a relatively clear rule with maybe some caveats to it in the injunction area. But inequitable conduct, I think, is a complete disaster area as an area of doctrine right now. And again, it takes us away from invention. Because patent lawyers say, you don't have to just do a great invention. You got to pay me a lot of money because they're just so complex rules about inequitable conduct. Currently, the Federal Circuit has just recently, this past year, said that in terms of judging materiality for purposes of inequitable conduct, there are 5 separate standards that all apply. Now, I just think that is not such a great way to run, your materiality test. There are 5 of them, and they all apply non-exclusively. I think that's not so wild. And they've also shortchanged the PTO's ability. One of those standards is what the PTO says is material. And they said, that's just one of them. We've also got our case law. And indeed, the entire inequitable conduct doctrine is built on extraordinarily rickety Supreme Court precedent. Basically, a single case with extreme facts where there was conceded perjury, both before the Patent Office. And that's the only case, the only precedent on inequitable conduct in the entire Supreme Court area. So when people think the Supreme Court is hostile to patents, it's Federal Circuit not so. It's not as straightforward as that.
I read the comment on.
Oh, absolutely, please.
On the inequitable conduct, the Federal Circuit's inequitable conduct rules. I mean, if you look at them as a body of rules, the rule that I see the Federal Circuit telling us is that don't allege inequitable conduct. When talking with clients now and making a decision about whether to allege that as a defense, we don't unless it's really clear because what I'm hearing from the Federal Circuit's case law is we're going to make it more difficult, even more difficult to succeed with that as a defense, and we're frowning on them, and the courts just don't like us all pointing fingers at each other and saying, you committed fraud, no, you committed fraud, and you did as well. So there are, I think Professor Duffy's right in that there are, the questions of what rises to the level of materiality. There is a lot of confusion in the case law on it, but the overall point I think the court has come at us with is don't allege it and don't try to prove it unless you've got a great case, with the exception of the Fairing case that came out in 2006.
And Purdue, too, which
Purdue as well. Fairing, I thought, was the worst case of 2006 from the court.
Don't say that too loud.
Well, I do think that. It's, the grant of summary judgment of ethical conduct is a very serious thing, and then to have it affirmed without giving the patent holder the ability to sit in front of the judge and jury and have their credibility evaluated, and to have the opportunity to tell their story, I think was wrong.
Yes, Eric.
I have a question for Professor Long and whoever else wants to chime in. You mentioned that you thought that higher costs would be a good solution to reduce the number of patents. And I'm wondering if you would feel comfortable putting a ballpark number on that, and if you could also comment on what you think a reasonable fee in terms of legal costs would be. And then beyond that, how do we ensure that non-corporate players can still participate in the patent system?
The way the system is right now is large entities pay twice what small entities pay. And I'm not going to suggest, without a lot more thought about it, what an amount should be. I think that's something for people much wiser than I to try to solve. I do think, though, that given that the filing fees are as low as they are, depending upon which transaction you're doing, ranging from a couple $100s to a couple $1,000, that for large corporations, at least, that are filing bulk patents and are getting their thousands of patents per year, that raising the cost to them can be a way of causing them to think a little bit more before they patent so much in bulk. But I'm not going to propose an amount as to what that is. And you had a second part to the. Yes, for small entities versus large entities. I would be much more wary about raising costs for small entities than for large entities, because it's not the small entities that are engaging in bulk patenting.
And I believe John Duffy also wanted to comment on that question.
I think that if you look actually at history, particularly in the 19th century, the difference between the United States system and the British system, one of the things you realize is that high cost can be a substitute for good patenting standards. In other words, if you don't have an obviousness doctrine, or a very vigorous obviousness doctrine, which is true in England in the 19th century until the very last decade or two of the century, they simply had a novelty-only system. And you say, how could they get away with that? I mean, because the United States had the development, probably half a century or more earlier than Britain. And part of the reason, I think, is because in Britain it was extraordinarily hard to get a patent. Charles Dickens actually had a story, a sort of joke story, about somebody who keeps going around trying to get a patent, and all he winds up doing is expending all of his money because there were extraordinary formalities associated with it. Whereas the U.S. was very patent-friendly, which meant it was very easy to get a patent, but that meant that the U.S. more quickly realized that you had to have some devices to put a limit on bad patents. And the devices that the U.S. came up with are the obviousness, or then it was called the invention doctrine, and also a bureaucratic system a decent bureaucratic system of trying to winnow out the bad patents. The British didn't have an examination system to really the beginning of the 20th century. And it was pretty late in the 20th century where they actually sort of fully implemented it. I actually think it would be better if the U.S. continued its pro-patenting tradition of trying to keep costs low, and certainly not distinguish between small versus large inventors. That's something that is really between, how industry organizes itself between vertically integrated firms or small firms should be something I think the government should be neutral about, generally speaking. I think we should be generally pro-patent and actually try and have patents available and try and get the substantive standards right.
Yeah, if I could just have one follow-up. Here's sort of a big picture point, but something that I've always liked very much about the U.S. patent system is that it has very strong democratic instincts. If you compare that with copyright, copyright is much more elitist in certain ways. But one of the reasons that the Patent and Trademark Office was founded in Andrew Jackson's administration was to try to make sure that the common man had access to the patent system. Because before this, before the PTO was created, there were 3 patent examiners, Secretary of State, Secretary of War, and the Attorney General, and of course these are elites. And the concern was that the common man was being shut out. And I think there's some expressive value in having this very democratic system, the idea that individuals ought to be able to have access to this. And as far as Professor Duffy's point about the government not distinguishing between small entities, or shouldn't distinguish between small entities and large entities, 2 points to that. First of all, we make these sorts of characterizations and we make these sorts of distinctions all the time. We do it in
There are a
tax
lot of things
law,
government does
we do
all the
it
time that
all
aren't
the
so good.
time. And in this case, I think it's actually a pretty good distinction because small entities pretty much sole proprietorships. So it's not government trying to figure out how to stratify a particular industry. It's separating out people who are patenting in their own names, who are sole inventors, from pretty much everybody else. So, and that's a distinction that I think is much more bright line for people who like rules, which I know you don't, than the way that
I like
you,
rules just fine. in some
Sometimes,
areas.
right. You have a standard for when you like rules.
Or maybe a rule about when I like rules.
Oh, do you have a rule?
I think I might have a rule about when I like rules in jurisdiction.
Okay, so you have rules about when you like. Okay, that's good. Well, we have unfortunately run out of time. I apologize for those of you who I didn't call upon, who probably were patiently waiting. I, may have missed some folks, but I would encourage all of you to grab our wonderful panelists, by the lapel and ask them your questions if you did miss out. And we exit and get, Jennifer, is this lunchtime now? Oh, so Jennifer knows much more than I do about everything, so she's going to tell you what to do.
So lunch will be set up on tables outside and beverages. So please just proceed into the loggia where you were during break and when you registered and pick up a lunch and head off to either the Birdman Lounge if you're not registered for a breakout session, or head to the room for the breakout session you've been assigned to, the list of which is in the folders you received at registration. Oh, and I've told all the breakout sessions should end at about 10 minutes prior to the introductory remarks for Judge Dyke. So if you guys could, everyone head back here in time.